Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today's the day I earned that subscription. For today's story, we're going to do part one of two, relating to different court decisions in the aspects of transgender athletes, a story that is continuing to be controversial in both public at large and in the courts. And these court decisions are getting to the point where it looks like the US Supreme Court might have to get involved. So today will be the tale of two decisions that look at these issues, and we will try to highlight some of the legal analysis that applies as the courts are thinking about this as we look to potential involvement from the US Supreme Court. Let's get started with this. Our first story takes us to the great state of West Virginia in the case of BPJ versus West Virginia State Board of Education. Today's decision, we're going to read an underlying district court decision. It is important to note here that this has been appealed to the Court of Appeals, which has issued an injunction against this decision, and it is possible the US Supreme Court will get involved. But the Court of Appeals decision issuing the injunction against this didn't really provide a lot of reasoning unto itself. BPJ is an 11-year-old transgender girl. That means that although BPJ's biological sex is male, she now identifies and lives as a girl. According to her first amended complaint, BPJ began expressing her female gender identity when she was 3 years old. So, right away, we're starting with some interesting issues of potential controversy because this involves a particularly young person who says that from the age of 3, they've been transgender, which I will take note is potentially an issue of controversy in our society. So we will simply note that is what she has said about herself, that though born biological male, starting at the age of 3, she's identified as a girl and lives life as a girl today. Okay. That apparently is a thing that is ongoing in this court case. In 2021, as she prepared to enter middle school, BPJ expressed interest in trying out for girls cross country and track. When her mother, Heather Jackson, asked the school to allow BPJ to participate on the girls' team, the school initially informed her as to whether or not she'd be able to be permitted to play would depend on the outcome of a House bill that at that time was still pending. When the law was passed and signed into law, the school informed Miss Jackson that she'd not be permitted to try out for the team. So the reason that she's not being permitted to try out for the girls' team is because the state legislature has said no. So the question, is the state legislature allowed to make that choice? And does their choice make sense? First, we must, of course, turn our attention to the language the West Virginia legislature has written, because as we're trying to interpret these things legally, it's very helpful to understand what the law says. So what did West Virginia do? In their code, they created a law that was entitled Clarifying Participation for Sports Events to be based on biological sex of the athlete at birth. Pretty clear what they're trying to do. The law, which was clearly crafted with litigation such as this in mind, the law says the following. There are inherent differences between biological males and females, and these differences are cause for celebration, as determined by the US Supreme Court in United States versus Virginia in 1996. These inherent differences are valid justification for sex-based classification when they realistically reflect the fact that the sexes are not similarly situated in similar circumstances. In the context of sports involving competitive skill or contact, biological males and biological females are not, in fact, similarly situated. Biological males would displace females to a substantial extent if permitted to compete on teams designated for biological females, as recognized in Clark versus Arizona, a Ninth Circuit decision from 1982. Although necessarily related, as concluded by the United States Supreme Court in Bostock versus Clayton, gender identity is separate and distinct from biological sex to the extent an individual's biological sex is not determinative or indicative of gender identity. Classification based on gender identity serves no legitimate relationship to the state of West Virginia's interest in promoting equal opportunity for biological sex. Classification of teams according to biological sex is necessary to promote equal opportunity outcome for female sex. And after making these findings, the law sets forth definitions of biological sex, female and male. So always helpful to define your terms when you're writing a law. Courts like it when they do that because it leaves less for the courts to figure out as to what the legislature wanted. So West Virginia defines, at least for the purposes of this particular law, West Virginia defines biological sex to mean an individual's physical form as male or female, based solely on an individual's reproductive biology and genetics at birth. So this is biological determinism. Sex is biological. Female means an individual whose biological sex determined at birth is female. As used in this section, women or girls refers to biological females. Male refers to an individual whose biological sex determined at birth is male. As used in this section, men or boys refers to biological males. Finally, the law requires that each athletic team that is sponsored by any public secondary school or state institution of higher education to be expressly designated either male, female, or co-ed based on biological sex. And then notes that teams that are designated female shall not be open to male sex except as might otherwise be provided for by law. Okay, my friends, so we've got West Virginia trying to define sex based on biology. It is biological in its nature. What woman is and what man is biology as determined by genetics and biological elements. So that is what West Virginia and West Virginia alone has defined it for the purposes of this particular state law. Incidentally, not necessarily for the purposes of all state law, because it is possible that West Virginia, of course, has defined it differently as to some other aspect of law. But as to this particular aspect of law, as to this particular statute, these are the definitions, biological in its nature. Summary judgment is appropriate where there is no genuine dispute of material fact and the movement is entitled to judgment as a matter of law. Yeah, this seems completely ripe for summary judgment. There is no dispute of fact. No one disagrees as to the facts. Everyone agrees as to the biological sex the person was born. Everyone agrees as to the gender or sex, depending on how you want to phrase it, but whatever. Everyone agrees how they identify now, let's put it that way. Everyone agrees this person wants to try out for a female team. Everyone agrees this person is not being allowed to try out for the female team because of this law. There is no dispute of fact. Everyone agrees as to the facts. So summary judgment is completely appropriate for at least one of the parties because there's nothing for a court to do except say what the law is. Can you do this or nothing for a jury to do? So what is the law? The student who wishes to compete alleges that the law in question violates the Constitution and Title IX. So her argument is that these are in conflict with specific federal laws. The 14th Amendment Equal Protection Clause, which requires equal protection under the law, and Title IX, which deals a lot with sports, in particular as it relates to sex discrimination by the government. So they are saying that these are choices the state is not allowed to make. They are saying that federal law speaks to this issue in a way that preempts the state's particular choices. Let's read the analysis to see if the court agrees. In the amended complaint, the student athlete alleges that the law was introduced in the legislature for the purpose as part of a concerted nationwide effort to target transgender youth for unequal treatment. They allege the law was targeted at and intended to affect only girls who are transgender, basically arguing that the motivations are one of animus. In the summary judgment motion, the student athlete again points the court to actions of a particular delegate, state level legislature, and points to several instances where legislatures made clear the purpose of the bill was to address transgender participants in sports. Notwithstanding these particular statements, the student does not argue the law is unconstitutional under the Supreme Court's animus doctrine, and the record reflects that it does not have sufficient action to make the finding. So this goes to the first basis on which a government needs to act. A government to act needs at least rational basis and may require more than that, depending on what they're trying to do. So your bare minimum threshold to get out the door is rational basis. If it's not rational, then you can just stop the analysis. The government can't do it. And the courts are clear that animus, hatred alone, is not rational. You can't do it merely because you don't like a thing. You need a reason other than I don't like the thing. Something else would be helpful. A law is unconstitutional under animus doctrine if the reason for passage is bare desire to harm. While the record before the court does reveal that at least one legislature held or implicitly suggested a private bias against or mere moral disapproval of transgender students. It does not contain the type of evidence that animus is more broadly held throughout the state legislature. Ultimately, the student athlete's issue here is not with the state offering girl sports and boy sports. It is with the state's definition of girl and boy. The state has determined that for the purpose of school sports, the definition of girl should be biological female, based on physical differences between sex. And the state argues the definition is appropriate here because it substantially relates to important governmental interest. That would be intermediate scrutiny, which is typically what you do when you discriminate on the basis of sex, intermediate scrutiny. Substantially related to important governmental interest. The student athlete, for her part, seeks declaration that she is a female. So one could raise the issue that the problem is that there are different sex-based teams. That could be the problem. The problem could be that there are boy teams and girl teams. Maybe that's the problem, that you are segregating girls away from boys. But that's not the argument. The argument isn't the problem is that there are girl teams and boy teams. The problem is you're not letting me participate on the girl team. The court notes it will not get into the business of defining what it means to be girl or woman. The courts have no business in creating these definitions and be hard pressed to find many other contexts where one's sex or gender are relevant considerations. But I'm forced to consider whether the state's chosen definitions pass constitutional muster in this one discrete context. So the court notes, somewhat thankfully, I assume, that it does not have to figure out what a man and woman is or a boy and girl is. It doesn't have to figure it out because the legislature has told the court. So that's one less thing the court has to do. When it relates to federal law, of course, this is going to be more of a problem because I don't think there are definitions that apply in the federal law. So some court somewhere is probably going to have to figure out what it is, but this court doesn't have to figure it out today. The court's thankful for that. The Equal Protection Clause of the 14th Amendment provides that no state may deny any person within its jurisdiction equal protection of the laws. In other words, all persons similarly situated should be treated alike. Yeah, that last part is really critical. Similarly situated. When you're talking about equal protection, you can't discriminate against people for completely arbitrary reasons. Some distinctions will matter for some purposes rather than other purposes. For example, if you're discriminating against the blind as the government, there are contexts in which that might be proper. For example, a driver's license. Maybe the blind shouldn't have driver's licenses, but perhaps less relevant to other categories, like should they be allowed to go to museums? Seems less relevant to that context. So the nature of the thing depends also on the thing that you're looking at as to whether or not it's proper. But if they're similarly situated, should they be allowed to go to a museum? How is blindness relevant? It's really not. Should they be allowed to drive? Much more so. Yeah, you have to treat similar things similarly and different things different within their respective domain. Ultimately, if a law seeks to treat different groups of people differently, it must do so upon some ground of difference, having a fair and substantial relationship to the object of the legislation. In the middle of rational basis review, which is your bare minimum, and strict scrutiny, which would be like if we're discriminating on the basis of race, lies an intermediate scrutiny. Intermediate scrutiny applies the law that discriminate on the basis of quasi-suspect classifications like sex and transgender status, which is a quasi-suspect status. The party defending the statute must present sufficient probative evidence in support of stated rationale for enacting sex-based preference. That is, the evidence must be sufficient to show the preference rests on evidence-informed analysis rather than stereotypical generalizations. So the court notes that sex-based discrimination is not treated the same as race under the current law. Race is strict scrutiny, meaning it must be a compelling governmental interest and narrowly tailored, and good luck with that. Sex-based discrimination is not treated as seriously because the courts have said that while sex-based can be used to just meaninglessly discriminate, there are differences that matter with respect to men and women. There is no debate that intermediate scrutiny applies to the laws at issue, and even this particular student athlete agrees. The state has important interest in providing equal athletic opportunities for female students. The student at issue in this case argues that the law excludes students from sports teams based on biological sex and defines biological sex solely in terms of reproductive biology and genetics. According to the student athlete bringing this case, The law uses a ends-driven definition of biological sex to guarantee particular outcome, barring girls who are transgender from qualifying as girls for the purposes of school sports and thereby categorically excluding them from girls' teams and therefore from school sports altogether. The state points to a long-standing recognition in the courts that physical differences between men and women are enduring and renders the two sexes to be non-fungible. You can't merely exchange the one for the other. There are differences that matter. The record before the court does make clear that in passing the law, the legislature intended to prevent transgender girls from playing on girls' sports teams. In making that decision, the legislature considered an instance in Connecticut where two transgender girls ran on a girls' track team and won at least one event. Cisgender girls there sued, claiming the state's policy allowed transgender girls to play on the girls' team violated Title IX. But acting to prevent the transgender girls, along with other biological males, from playing on girls' teams is not unconstitutional if the classification is substantially related to an important governmental interest. The state's interest in providing athletic opportunity to females is not an issue here, and the student athlete bringing this case does not argue that sex-separate sports in general are not substantially related to the interest. Okay, so we have the conflict teed up well between the two sides. The issue is not whether or not there should be girls and boys teams, at least not for the moment. Someone could make that argument, but that is not the argument at the moment. The argument is girls and boys teams are good. We should have girls and boys teams. And so the one question we might ask is, are gender and sex the same thing? Are they different things? How do we look at this question? So the court next has to analyze the degree to which sex and gender are different or the same, at least as far as this court's concerned. The court writes that while sex and gender are related, it is not the same thing. The court notes that it is beyond dispute that barring rare genetic mutations not an issue here. A person either has male sex chromosomes or female sex chromosomes. Gender, on the other hand, according to the court, refers to a set of socially constructed roles, behaviors, activities, and attributes that a given society considers appropriate. Gender identity, then, is a person's deeply held core sense of self in relation to gender, according to this court. So this court thinks that there is a difference between sex and gender, which, of course, will be an issue as the courts are trying to decide this. Is there a difference? And assuming there is, does the law protect only one kind or the other, or does it matter? What is the nature of it? So that's a whole thing, but let's press on. When one's gender identity is incongruent with sex, that person is transgender. To be transgender, one must hold a consistent, persistent, and insistent conviction. Their gender is on a binary opposite to biological sex. Okay, so this court thinks that there is a difference that exists between sex and gender. But then, of course, the question might be, are we discriminating against them because of sex? Are we discriminating against them because of gender? Are we discriminating them because of both? When you have men's and women's teams, are those sex-based determinations or gender-based determinations? So maybe it's true that gender is irrelevant in this context, because if men and women's teams are sex-based, then one's gender is by its nature irrelevant. So it's not even worthy asking the question, because there may be the nature of it is biological, sex and gender. Yeah, have any gender you want, but that's not how these teams are being decided. So what is the argument that looking to biology is a determinative factor, at least in this context? Whether a person is male or female, based on sex chromosomes, determines many of the physical characteristics that are relevant to athletic performance. Those with male chromosomes, regardless of gender identity, naturally undergo male puberty, resulting in an increase of testosterone. This particular student athlete herself recognizes that there is a medical consensus that the largest known biological cause of average differences in athletic performance between male and females is testosterone that begins with puberty. While some females may be able to outperform some males, it is generally accepted that, on average, males outperform females athletically because of inherent physical differences between the sexes. This is not an overbroad generalization, but rather a general principle that realistically reflects the average physical differences between the sex. So, to some degree, you have to generalize, of course, if you're going to have categories. You have to make generalizations. So, the question is this a generalization? The question is it an overbroad generalization? And the court says no, because as to this particular aspect, we are looking at athletic performance. Athletic performance is to large degree physical by its nature. So, when we're looking at physicality, we're looking at something that directly relates to the athletic performance in question. This doesn't necessarily apply to other contexts. So it is completely possible, at least legally, to have one determination in one context and a different determination in a different context. So this is not necessarily an all or nothing proposition. It could be, obviously, we could have the same determination in every context. But what the court is noting is that it's possible, at least, to look at this in a context sensitive way. And at least as this particular context, whatever might be true in other contexts, there is differences that matter as it relates to physical performance, which is to a large degree biologically. And while it might be true that some women will outperform some men, if we're going to treat this by its nature as a broad categorization, because we're looking to athletic performance based on sex, right? In part of the briefing, the student athlete asks the court to find that specifically excluding transgender girls from the definition of girl in this context is unconstitutional because transgender girls can take puberty blockers or other hormone therapies to mitigate any athletic advantage. While this may be true for this particular student athlete, other transgender girls may not take those medications. So this is part of the problem. This is part of your definitional problem, right? If transgender girls should be allowed to participate, and one of the reasons that you say that they can't is based on biological concerns. So what if we mitigate the biology? Okay. So does that mean that for them to participate, they have to have been taking hormone blockers since the beginning of puberty? Is that the relevant rule? What is the relevant rule? How are we measuring this thing? So you see one of the problems is you're substituting a different line for the legislature's line. The legislature has said birth is the line. What's true at birth? And you said, okay, how about not birth? How about if they've been taking puberty blockers? Okay, since when? Are they total blockers, partial blockers? What if they start? What if they stop? What if they restart? Another line. And one of the problems is that courts don't typically do this kind of line drawing. The legislature gets to make these choices because the legislature is the one who gets to make policy. And so the question isn't, is this the best place for the line to exist? Because maybe it's not. The question is this a legal place for the line to exist? Maybe it should be if you've been taking puberty blockers since puberty. Maybe that's the relevant standard, but is this court allowed to override the legislature's choice? Not if it's constitutional. And also, what's true of you is not true of everyone. And the law, by its nature, has to somewhat generalize. The fact is, however, that a transgender girl is biologically male and barring medical intervention would undergo male puberty like other biological males. And biological males generally outperform females athletically. The state is permitted to legislate sport rules based on sex and physical characteristics that flow from it that are substantially related to athletic performance and fairness in sports. Sex-based classifications fall under intermediate scrutiny and therefore do not have a narrowly tailored requirement. As intervener, Armstead points out that some boys run slower than the average girl, and some boys have circulating testosterone levels similar to the average girl because of medical conditions or medical intervention. But the student that's bringing this lawsuit denies the latter would be similarly situated to cisgender girls for the purposes of Title IX and equal protection, and does not argue that they should be allowed to play on girls' teams. All right, so the court so far has dealt with the equal protection issue under the Constitution. Intermediate scrutiny is the relevant standard. Sex-based discrimination typically treated intermediate scrutiny, and the court treats this no differently and notes that this is an important interest and it is rationally related to that interest or tailored to that interest, depending on the exact phrasing. And the court notes that that's fine under the Constitution, which makes total sense. But of course, there is the federal law Title IX, which also deals with this issue. So we also have to look to see if Congress has amended or at least increased the protections under the Constitution by use of Title IX. So let's go ahead and look at that. Title IX of the Civil Rights Act provides that no person shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subject to discrimination under any education program or activity receiving federal assistance. The student athlete who brings this case argues the law that the state passed violates Title IX because it excludes transgender girls from participation on girls' sports teams. The student argues that this amounts to complete exclusion from school sports altogether, and that this discrimination is because she and other transgender girls are similarly situated to cisgender girls. The state responds the law does not violate Title IX because it does not exclude the student from student athletics. To the contrary, it simply designates on which team the student shall play. And the county defendants argue that Title IX authorizes sex separation in sports in the same scenarios outlined in the law, where selection for such teams is based on competitive skill or activity and is a contact sport. All defendants argue that while it did not define the term, Title IX uses the term sex in a biological sense because its purpose was to promote sex equality. So, when Title IX, the federal law, which was written in 1964, used the term sex, it meant biology because that's how people used the term in 1964. Yeah. Title IX authorizes separate sex sports in the same manner as this law. So, as long as overall athletic opportunities for each sex are equal, they are same. And as other courts that have considered Title IX have recognized, although regulations apply equally to boys as well as girls, it would require blinders to ignore that the motivation for promulgation of the regulation was to increase opportunities for women and girls in athletics. There is no serious debate that Title IX's endorsement of sex separation in sports refers to biological sex. Thus, the court, in considering the law under intermediate scrutiny standard, finds that the law is substantially related to important governmental interest, and thus the motion for summary judgment is denied. Thus, that brings us to the end of consideration of this district court case from West Virginia in the case of BPJ versus West Virginia. Again, I'd like to note that this has been appealed to the Fourth Circuit, and the Fourth Circuit has put in place an injunction preventing this decision from going into effect, at least for the moment. So that may or may not speak to the future, and the Supreme Court may or may not take up the injunction review and deal with that, or they might wait for the court to decide things on the merits and it to go through the appeals in that fashion. So this may or may not get Supreme Court treatment in the near future, but either way, this issue is beginning to percolate through the courts. And we're beginning to see decisions, and these decisions are beginning to conflict. In our next decision, we are going to discuss a decision that conflicts on very similar grounds as it relates to powerlifting and competition in powerlifting in face of a different state law, which is going about this in a completely different fashion. So it'll be interesting to see how these court decisions look at these issues. Until next time, my friends, I hope all's well. Cheers, my friends, and goodbye.